In today's video, I'm going to discuss immediate relative petitions. That is, a petition by a U.S. citizen of their parents, spouse, or minor children under 21. The main takeaway is one person per petition. In other family petitions or employment-based petitions, a single petition can cover many family members, but not with immediate relatives. Now, how can that situation come into play in your case? If a U.S. citizen is going to petition his or her parents, each parent must have their own petition. You cannot file one petition for both mom and dad. If a U.S. citizen has several minor children, each child has to have their own separate petition. If a U.S. citizen has a spouse and minor children, each family member has to have their own petition, one for the spouse and one for each of the children. Now, along the same lines, an immigrant can petition his or her spouse and minor children under category F2A, and a single petition can cover all of them. But if that immigrant naturalizes before the family members get their visas, only the spouse would be covered upon naturalization, and the children would fall off the petitions. I remember I had a consultation one time where an immigrant had petitioned his wife and 3 children, and before they went to the embassy for the interview, he took the oath of citizenship. When the wife and kids got to the window, the consul said, sorry, only the wife or mother gets the visas, the kids fell off the petition. Well, she was not happy. He had to rush out and quickly file new separate petitions for each children. So in those circumstances where an immigrant is petitioning a spouse and children, they can either remain an immigrant until the visas are issued, or at the very outset, if they're thinking about naturalizing, file F2A petitions for each family member, the spouse and the children. So when he naturalizes or she naturalizes, there are already petitions in place for all of the family members. Another situation where this may come into play is where a U.S. citizen may petition a teenage daughter, and she got pregnant and she gave birth. Her child, which is the petitioner's grandchild, would not be included in the petition because with immediate relative petitions, no derivatives would be allowed. What would have to happen in that particular case is that the daughter would have to come into the U.S. and then eventually petition her child as a mother of a minor child, category F2A. I have seen it happen many, many times, and it can be confusing. And people would say, when I would say one person per petition, no derivatives, they said, I didn't know that. Well, that's the purpose of these types of videos, to keep you informed of immigration developments as well as immigration laws, rules, and procedures. I'll be giving you more videos about family petitions, the tips and tricks and little known facts about them. If you like these videos, make sure to like, share, and most importantly, subscribe. I'm Michael Gurfinkel, and this is U.S. Immigration TV.